the last subsection of the rules, judicial conduct. This subsection of the rules makes up 2 to 8% of your total MPRE examination. I know a lot of people ask if they can simply skip or quickly read over or skim judicial conduct because it makes up rather a small percentage of their total examination, but I wouldn't. Obviously, the best way to be prepared and to hopefully pass the MPRE is to be prepared for any sort of question that they throw your way, which of course can include judicial conduct, because as I just stated, while we are at the last subsection of the rules, it can still make up 2 to 8% of your total examination. So I would recommend giving all of the rules a read and studying them carefully. The first rule here that I want to point out is all about a judge's requirements to perform the duties of their judicial office impartially, competently, and diligently. Specifically, the rule that I want to talk about discusses the judge's ability, which is heightened or added responsibility than the average lawyer has when it comes to doing things like reporting misconduct and discussing with attorneys whether or not they're dealing with some sort of disability or impairment. So the first rule I want to talk about says that a judge having a reasonable belief that the performance of a lawyer or another judge is impaired by drugs or alcohol or by some sort of mental, emotional, or physical condition shall take appropriate action, which may include a confidential referral to a lawyer or judicial assistance program. It may also include speaking directly to that person. So here, we didn't encounter a rule like this for regular lawyers. So again, this is a heightened responsibility for judges. So if a judge comes to know that another lawyer or maybe even another judge that they're working with is being impaired or struggling with maybe a substance abuse issue or a health issue, they are required to take appropriate action. But what this rule essentially says is that appropriate action can differ based on the circumstances. It might be simply referring the lawyer or the judge to get some help. It might just be having a conversation with them to address whatever issue is going on. But nonetheless, the rule requires that the judge takes appropriate action under the circumstances. The next rule that's in a similar vein discusses what a judge should do about reporting a lawyer and other judges' misconduct. This rule should sound very familiar. So the language of the rule says, a judge having knowledge that another lawyer or a judge has committed a violation of these rules or the model rules of professional conduct that raises a substantial question regarding that judge's or that lawyer's honesty, trustworthiness, or fitness as a judge or as a lawyer in other respects shall inform the appropriate authority. So I said that this rule should look familiar because it's identical to the rule for us lawyers when it comes to reporting professional misconduct. So just a few things I have to say about it. Remember that this rule utilizes the word knows. There's a knowledge requirement here. So if a judge comes to know that another lawyer or judge has committed a rule violation, that would trigger this rule. Additionally, this rule says if you come to know that another judge or lawyer has committed a rule violation, and that type of violation raises a substantial question to their honesty, trustworthiness, or fitness in other regards, then you must report them. So again, to be clear, this does not mean that every single rule violation must be reported. If you have knowledge of a rule violation and it's the type of thing that raises a substantial question about their honesty, trustworthiness, or fitness, then yes, you shall report them. But we're not done yet. There's an additional requirement for judges. The additional rule says a judge who receives information indicating a substantial likelihood that a judge or a lawyer has committed a violation of these rules shall take appropriate action. This could be talking to the judge or the lawyer, or it could mean reporting it to the proper authorities. So this is an obligation that a regular lawyer isn't faced with. It's an additional responsibility that is put on judges. So again, kind of the big words here that I'm hoping jump out at you or draw your attention is that substantial likelihood. So here, even if a judge doesn't have knowledge that another lawyer or judge has violated these rules, but they have enough information that creates that substantial likelihood that a violation occurred, they are required to take the appropriate action under the circumstances. So again, it's this heightened obligation that other lawyers who are not judges are not faced with. The final rule in this vein is all about cooperating with disciplinary authorities. The rule says a judge shall cooperate and be candid and honest with judicial and lawyer disciplinary agencies. A judge shall not retaliate, whether it be directly or indirectly, against a person known or suspected to have assisted or cooperated with an investigation of a judge or lawyer. And I think this rule makes sense. We as lawyers, whether you're a judge or not, obviously have an obligation to report misconduct. As a result, we have an obligation to also comply and be cooperative with any sort of disciplinary authority that's investigating. And that is why this rule is here for judges as well. Switching gears just a little bit, I want to talk about the rule regarding disqualification. So the general rule is a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. So just to stop there before we talk about all of the circumstances that the rule lists, the general rule is that a judge must disqualify themselves in any sort of proceeding where their impartiality might be questioned. So I do want to be clear here. A lot of people think that these enumerated circumstances are the only circumstances in which a judge must disqualify themselves. But that is not what this rule is communicating. The rule is just listing certain circumstances where a judge's impartiality would be questioned, and therefore they shall be disqualified. But the general rule is any circumstance in which their impartiality would be questioned should result in the judge disqualifying themselves. So let's talk about some of these circumstances listed in the rule. The first is when the judge has some sort of personal bias or prejudice concerning a party or a party's lawyer, or has personal knowledge of facts that are in dispute in the proceeding. Secondly, if the judge knows that the judge or their spouse or their domestic partner or a person within the third degree of relationship to either of them or their spouse or domestic partner of such a person is a party to the proceeding or is some sort of officer, director, general partner, managing member, or trustee of a party that's involved in the matter before the judge, or is a lawyer in the proceeding, or a person who has more than a de minimis interest that could be substantially affected by this proceeding, or likely to be a material witness in the proceeding. That's a loaded set of circumstances, so just to stop for a second, what this rule is saying is that if there's a scenario where, say, maybe the judge is not a witness, but the judge knows that their kid is or their spouse is, that's a good set of circumstances to disqualify themselves. Or, while the judge might not be the lawyer in the proceeding, obviously, in front of them, but, if, say, the judge's spouse is, that's a good set of circumstances to disqualify themselves from the proceeding. So again, this rule is not just limited to the judge's own interest, but also those people in which the judge is related to, because obviously your family and people in which you have close relationships to can affect the way you handle situations and therefore question your impartiality. The next circumstance that's enumerated says if the judge knows that he or she, individually or as a fiduciary, or if the judge's spouse, domestic partner, or if their parent or child, or any other member of the judge's family residing in the judge's household has an economic interest in the subject matter in that controversy, or is a party to the proceeding. So again, here this rule is a little expansive. It's saying if the judge has an economic interest in the matter, they shouldn't hear it. Or if anyone in the judge's household has an economic interest in the matter, they shouldn't hear it. So again, it's expansive. It's trying to cover all of the possible circumstances. The next set of circumstances says the judge should disqualify themselves if the judge knows or learns by means of a timely motion that a party's lawyer, or the law firm, or a party's lawyer has within the previous years made a certain number of contributions to the judge's campaign. So again, to stop, this is a scenario where maybe the judge doesn't have this information, readily at their hands. But if the judge comes to learn that the people or the parties in front of him or her were big contributors over a certain number of years to their campaign, that is definitely a scenario where the judge's impartiality would be questioned. And that is a scenario when the judge should disqualify themselves. The next scenario is if the judge, while serving as a judge or as a judicial candidate, has made a public statement other than in a court proceeding or in a judicial decision or an opinion that commits or appears to commit the judge to reach a particular result or rule in a particular way in that proceeding or controversy. Because again, if the judge has made some sort of public statement issuing, their opinion or saying that they feel a certain way strongly or that they would decide a case a certain way, this is obviously problematic because then the judge will not be, or at least will not appear to be, impartial for that matter or controversy before him or her. And then the last set of circumstances says the judge should disqualify themselves if the judge did any of the following. First, served as a lawyer in the matter or was associated with the lawyer who participated substantially as a lawyer in the matter during their association. So this means even if the judge didn't handle the case, but maybe one of the members at their firm did, they would have to disqualify themselves from hearing that case. Or if the judge served in governmental employment and in that capacity participated personally and substantially as a lawyer or a public official concerning that proceeding, or has publicly expressed in such a capacity an opinion concerning the merits of the particular matter in that controversy. So again, if the judge maybe was in public employment prior to taking the bench, the same rule applies. They should not have handled the matter and then hear it later. If they handled it, they need to make sure that they are not hearing it as a judge. Or the judge should disqualify themselves if they're a material witness in the matter, or if they previously presided as a judge over the matter in a different court. As it relates to the judge's obligations to disqualify himself or herself, if it's appropriate under the circumstances, the rule goes on to discuss that judges have an obligation to keep informed about their interests, as well as the interests of their spouse, their partners, or other people that reside in their household. The rule specifically says, a judge shall keep informed about the judge's personal and fiduciary economic interests and make a reasonable effort to keep informed about the personal economic interests of the judge's spouse or domestic partner and minor children residing in the judge's household. And if you take a step back and think about it, I think this rule makes sense since we are obviously concerned with the judge's ability to be impartial and to decide cases. We need to make sure that a judge is staying up to date about their own personal interests so that we are confident that they are impartial and that they are not committing any sort of ethical violation. In the same vein, let's talk about disclosure. The rule states that a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes that there is no basis for disqualification. So stopping there, this means that if the judge has any inkling that maybe if they were in the lawyer's shoes or if they were in the party's shoes, that there is some information that they know personally that they would want to know about the judge deciding or hearing their case, then they need to actually put this information on the record. That way the lawyers and or the parties that are involved in the action can decide what they want to do with that information. Maybe they decide that they want to file a motion for disqualification, or maybe they really don't mind at all and they're not really worried about that information that the judge has given them for full disclosure. The rule then goes on to talk about waiver. It says that a judge subject to disqualification under this rule, other than for bias or prejudice, may disclose on the record the basis for the judge's disqualification and may ask the parties and their lawyers to consider, outside the presence of the judge and the court personnel, whether to waive disqualification. If, following this disclosure, the parties and the lawyers agree without participation by the judge or by the judge's court's personnel, the parties and the lawyers agree together, again without all of this participation, that the judge should not be disqualified, then the judge can move forward and participate in the proceeding. However, this agreement that everyone reaches needs to be incorporated on the record of the proceeding. So again, to stop there, if the judge does decide that there is some information to be fully, transparent with the parties that they believe that the parties might want to know, the judge puts this information on the record. If the judge wants to ask the parties to waive disqualification, the judge can do so. But what the judge has to do is give them this information on the record and then allow the parties to go on their way, basically to leave the courthouse and to be able to talk amongst themselves and with their, lawyers as to how they feel about that information that the judge has given them. If they feel like it's no big deal and they want to waive disqualification, they have a right to do that. Or if they believe that the information that the judge gives them makes them feel like the judge cannot be impartial, then of course they have a right to ask the judge to disqualify themselves. If they do come back and decide to let the judge handle the proceeding, the judge will incorporate the parties' agreement on the record so that there is a record that this agreement and decision was made. Still on that rule, the rule goes on to say that a judge's obligation to not hear a case or decide a matter in which disqualification is required applies regardless of whether or not a motion to disqualify has been filed. So this means that a judge shall not wait until a party decides that the judge should not be hearing the matter. A judge, again, needs to take this upon themselves if they decide that they have information that would raise a question as to their impartiality to handle it ethically under these rules. And when it comes to necessity, the rules then go on to talk about how the rule of necessity may override this rule of disqualification. And this usually happens in a situation where maybe there's no other judge available to handle a very time-sensitive matter. But usually, if there were other judges available, or if the matter was not time-sensitive, the judge in question would not be handling it. Under those circumstances of necessity, a judge can handle that matter, make whatever time-sensitive decision needs to be made, but then, of course, needs to hand that case or matter off to someone else that is better suited to handle it. And that is what we mean when we say necessity may override this rule of disqualification. And then lastly, the fact that a lawyer in a proceeding is affiliated with a law firm with which a relative of the judge is affiliated does not itself disqualify the judge. If, however, the judge's impartiality might reasonably be questioned or the relative is known by the judge to have an interest in the firm that could be substantially affected by the proceeding, then the judge's disqualification is required. And again, I think this makes sense. Just because a judge might know someone or be related to someone at a law firm that is handling a matter in front of the judge does not automatically mean the judge has the inability to be impartial. Now, however, if the judge knows that the person they're related to will be substantially affected by the decision in the case, then of course the judge needs to take a step back and disqualify themselves or put this information on the record and ask for a waiver. But it's good to make that clear. Switching things up just a little bit, let's talk about the rules regarding judges' abilities to participate in extrajudicial activities. So the rule says that a judge may engage in extrajudicial activities. However, when engaging in extrajudicial activities, a judge may not do the following. They may not participate in activities that will interfere with the proper performance of their judicial duties. Being a judge should always come first, basically. They may not participate in activities that would lead to frequent disqualification of the judge, because again, that impacts their ability to do their job. They shall not participate in activities that would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. So again, if the judge maybe is participating with a group or has some sort of association with a group that practices, discrimination, a judge needs to cut ties with that organization or group. Finally, a judge is not supposed to engage in conduct that would appear to a reasonable person to be coercive. Lastly, the judge may not make use of court premises, staff, stationary equipment, or other resources except for incidental use for activities that concern things like the law, the legal system, or the administration of justice, or unless use of these things is permitted by law. So again, the judge should not be using court resources for their extrajudicial activities unless it's incidental, and those extrajudicial activities have to do with the law, the legal system, and the administration of justice. Similarly, the next part of the rule that I would like to discuss is a judge's ability to participate in different educational, religious, charitable, fraternal, and or civic-like organizations. The rule says that a judge may participate in activities sponsored by organizations or governmental entities that are concerned with things like the law, the legal system, or the administration of justice, and those sponsored by or on behalf of educational, religious, charitable, fraternal, or civic organizations not conducted for profit, including but not limited to the following activities. So these are all the things that a judge can do, but again, it is not a conclusive or complete list. A judge can assist this organization or entity in planning that's related to its fundraising. A judge is allowed to solicit contributions on behalf of this organization or entity, but only from members of their own family or only from members from which this judge does not exercise supervisory or appellate authority over. Because again, we do not want a judge to be coercive or to come off to a reasonable person as being coercive. So if they're going to fundraise, it has to be from, their friend or family members. They can solicit membership for such an organization or entity, but only if this organization or entity is concerned with the law, the legal system, or the administration of justice. They can appear and or speak at, they can receive awards or other sorts of recognition, or they can be featured in the program of and permit that their title be used in connection with some sort of event, but only if the of an event of this organization or entity in which they're participating. But if the event in question is serving a fundraising purpose, then the judge can participate only if that organization concerns the law, the legal system, or the administration of justice. So to stop there, you can see that these rules are essentially carving out like an exception for entities or organizations concerned with the law, the legal system, and the administration of justice. So if a judge is going to or speaking at an event or receiving an award at an event that does serve a fundraising purpose, the judge can only do that if it concerns the law, the legal system, or the administration of justice. Otherwise, the judge cannot participate in those types of events. The judge can participate in events if they do not concern or have a fundraising-like purpose. Judges can make recommendations to such public or private fund-granting organizations or entities in connection with its programs and activities, but only if the organization or entity is, again, concerned with the law, the legal system, and the administration of justice. They can serve as an officer, director, trustee, or non-legal advisor of such organizations or entities, unless it's likely that this organization or entity will be engaged in proceedings that would ordinarily come before this judge, or will frequently appear in the court in which the judge sits or under its appellate jurisdiction. So again, a judge can be quite involved, but we need to make sure that being involved is not going to cause them to have to, say, disqualify themselves or be unable to handle certain types of cases or matters that come in front of that judge's courtroom. Now, when it comes to the compensation of a judge for these extrajudicial activities, the rules state that a judge may accept reasonable compensation for extrajudicial activities permitted by these rules or by law, unless acceptance of this compensation would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. So just to stop there, you'll notice with this rule, there's not a hard and fast dollar amount that a judge can or cannot accept. Instead, the general rule is they can be compensated for their extrajudicial activities, but they need to be careful that the amount of money that they are accepting would not appear to someone else to call into question things like their ability to be impartial or independent. Because at the end of the day, a judge and their obligations to the bench need to come first. And then the last rule that I want to discuss is all about the reimbursement of expenses and the ability of a judge to receive the waiver of certain fees, charges, or expenses. So the rule states that unless otherwise prohibited by these rules or by another law, a judge may accept reimbursement of necessary and reasonable expenses for things like travel, food, lodging, or other incidental expenses, or a waiver or a partial waiver of fees or charges for things like registration, tuition, from sources other than the judge's employer or entity, if the expenses or charges are associated with the judge's participation in extrajudicial activities that are permitted by these rules. So to stop there, this means if the judge is participating in something that requires him or her to buy airfare to go to one of these events, maybe being put on by an organization that's associated with the law, the legal system, or the administration of justice, which again, they would be permitted to participate in by these rules, that entity can reimburse the judge for his or her airfare expenses. That is permissible. That's what this rule is saying. It goes on to tell us that reimbursement of expenses for necessary things like travel, food, lodging, or other incidental expenses shall be limited to the actual costs reasonably incurred by the judge and, when appropriate, on occasion, by the judge's spouse, domestic partner, or guest. So to stop there, if you see a question that kind of gives you in the fact pattern that a judge and his or her spouse are going to an event and they needed to get a hotel room or they needed to buy airplane tickets, both of them can receive reimbursement for the expenses associated with, say, that travel. So again, it's not just that the judge can receive reimbursement for themselves personally, it's for, say, their spouse as well. And that is totally and ethically permissible. But the rule then finally says, A judge must assure themselves that acceptance of reimbursement of these fee waivers would not appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. The factors that a judge should consider when deciding whether or not to accept reimbursement or a fee waiver for attendance at a particular activity include the following. So to stop there quickly, again, we need to be sure that if a judge is putting themselves in a position to accept these types of reimbursement or waivers, that they are being sure that their impartiality and independence and integrity cannot be questioned by the acceptance of these things. And then the rules give us a list of factors that basically outlines what the judge should consider when deciding whether or not to accept these types of waivers or reimbursement or compensation. I'm not going to go over all of the factors because, again, they're not exclusive, just a list of things that the judge could consider when making this decision. So some of those factors the judge could consider is whether or not the sponsor of these events is accredited, specifically as an educational institution or as a bar institution rather than a trade association or a for-profit entity. Another consideration could be whether or not the funding comes largely from numerous contributors rather than from a single entity and is earmarked for programs with specific content. Another thing to consider would be whether the activity is primarily educational rather than recreational, and whether the costs of the event are reasonable and comparable to those associated with similar events sponsored by things like the judiciary, bar associations, or similar groups. And then finally, another factor to consider is whether information concerning this activity and its funding and its sources are available upon someone making an inquiry. And then the last rule that I want to touch on and that I will leave you with is that a judge who accepts reimbursement of expenses or waivers or partial waivers of fees or charges on behalf of themselves or their spouse, domestic partner, or guest shall publicly report these acceptances as required by the rules. So there are specific rules that outline when a judge must report certain things like gifts and compensation or waivers. And basically that's just a reminder that if a judge is accepting some sort of reimbursement or fee waiver, it might be one of those things that have to be reported according to these rules. So that wraps up the rules that I'm going to cover from judicial conduct. I hope that you found that helpful.